Everybody, welcome again to Frequently Asked Questions Friday. We have our returning champion, Scott Staha, back with us.
Hello.
And Scott's topic today, he wants to talk about is social media and its impact on personal injury claims. So, Scott, let's get started. We're getting started a little bit late here. We only have about 10 minutes. So, I know before we started, you were telling me, you said there's basically two issues. One of them is the issue of judges or adjusters looking at people's social media and what they post on there. And then also the discoverability of it in court and whether it's relevant, admissible. And then the other issue was, well, it was just
how you can minimize.
Not, yeah.
Right.
All right.
Right.
So let's talk first about it. And for anybody that doesn't know, we've written a book on this, and it's on the website, or we've written a book on how not to ruin your case, the 7 deadly mistakes that will ruin your case. Are y'all passing those out to clients over there at your office?
Yes.
Okay.
Yes, we are.
Anyway, you can get a free book from us. You can go to our website and download an ebook, or you can write us a letter or call us and we'll send you one. But we've written a whole book on this, how not to screw your case up, basically. But so on this portion, and there's one chapter just on social media, but we're going to talk about it here again today. So Scott, let's do this first. Give us some examples of some of your clients that you have seen that have screwed their case up through social media. Yeah, I don't want any names or anything. But.
Right, and really, I won't even mention, won't even talk about our clients per se, but just in the context of listening to other attorneys talk about how either they have managed to find information that was very detrimental to the other side and vice versa. I can tell you that there was I can remember a story, a lawyer telling me, he was a defense lawyer, telling me how his client had been had caused a very bad wreck, and subsequently had gone online and basically just joked about the whole incident after, severely injuring an individual, and it came back to haunt them.
I bet it did.
At the time of trial. And that's just one of many examples, but it's also just in the context in general. We have presently, there's a case pending here where one of our pre-lit lawyers, Lane Diamond, was telling me about a case where he had an adjuster who had taken the time to investigate our client and had found some images on Facebook and was making an argument that, given what was depicted in the photograph, that she called into question his credibility about whether or not this individual was injured or not. And in looking at the photograph, while it was a very innocent picture, defense lawyers and adjusters are very good at taking out of context what may be a very innocent picture and using that to enhance their case, and defense lawyers, by the same token, using what may appear to be an innocent photo and using it to downplay injuries that a client may have.
Sure, and that's what defense lawyers do.
And that's what they do, and that's
they take anything they can and try to show you're lying somehow.
Right, even though the photograph in and of itself was very innocent.
Of course, we've had clients that have been injured elsewhere and have blamed it on an injury that they're making a claim on. I know we had a girl who her boyfriend broke her jaw and beat her up. And she posted that on social media, but she claimed all that came from the car accident she was in. So I know when the adjuster saw that, why are you telling the world your boyfriend did that? That didn't help her case much.
No, not it. Wouldn't help her case at all.
And then we've had clients that they like to drink a lot and smoke weed and do lots of drugs on social media. And now. Some clients may say, well, how would that be relevant and how would that come in? Why would some judge let a jury see that? And so tell us how that could harm your case, that you're partying and smoking weed and maybe doing some other drugs on Facebook or Instagram or wherever. I mean,
It can come in most of the time. It comes in through the fact that if a individual either through interrogatory answers or through deposition says that they can't do this, that, or the other, or they can't go out and do those things that they really enjoy doing or that they like to do, and you post up on Instagram or Facebook a 3-week vacation that you took, to the Grand Canyon, hiking up and down the trails, then it becomes relevant to your claim as to whether you're physically able to do those things and whether or not you can continue to do them in the future. And so that's how it becomes relevant is you create an issue by saying I can't do this or that, or I don't do it as well. And now we have evidence that, well, here you are doing it again.
Yeah, I understand hiking up the Grand Canyon. I was talking about more like, say, smoking weed or something. I mean, why should that come in?
Well, it depends on the context of the incident in and of itself. If there are allegations that one may have been consuming alcohol at the time or may have been intoxicated through other substances, it can lend credence. If you testified, for example, that you didn't do or you don't do drugs or drink, and then there's video of you doing it, goes to your credibility, and so it becomes admissible those ways.
I recall a case you and I tried about 5-6 years ago where we didn't think our client's cocaine use would come in, but the defense lawyer got the doctor on cross-examination outside the presence of the jury to say that, well, I think your client probably would have healed a lot quicker had he not been doing drugs, and then so he wouldn't have all these damages that he's got. And so the judge decided, well, then he should have mitigated his damages, and he didn't because he's doing cocaine instead of doing therapy.
Doing his therapeutic medications, he's taking extracurrurricular therapeutic medications.
And so the judge let it in, and luckily though in that case the judge told us before trial that he was going to let it in, so we got a chance
able to deal with it.
Yes, we got able to voir dire with it and got rid of most of the people that really held that against him. And so in that particular case we kind of salvaged it, but it could have just totally destroyed the case had we not been able to like voir dire the jury on it and kind of get the worst drug hater people out of there. So, all right. Okay. So then the second issue was how can people help themselves? Let's say they've got a bunch of stuff on social media, or they're thinking about putting stuff up. Or let me just ask it broadly: how can people help themselves?
Well, there's a couple of things that I would certainly advise them to do. One is, which unfortunately most people aren't going to follow, is don't post anything on your social media after the initiation of your claim. I understand that's probably not realistic, but I would advise anybody that whatever they're contemplating posting, to look at it from the eyes of, is this something that could be used or could be misconstrued and hurt my case, and therefore I'm not going to post it onto social media. Secondly, what I would advise everybody to do, and I think that we probably be able to help here, is to enhance your privacy settings on your social media accounts and limiting it to those most trusted family and friends, so that it's not available to, Jane Doe adjuster or, Mr. Defense Lawyer who can, with a few keystrokes, log onto your Facebook account and look at all of your postings that are all set in a public mode. And so I would tell everybody, please turn all of your settings to private. I will say, please don't remove anything from your Facebook account after the initiation of a claim, because it could be construed as the destruction of evidence. And there's some cases that are beginning to come down from appellate courts where clients and in some cases attorneys. There was a case out of Virginia where a attorney had advised the client to pull down some Facebook photos that were not very flattering. The judge ended up sanctioning the lawyer to the tune of almost $500,000, and the plaintiff in that case a couple $100,000. Court of Appeals actually upheld the sanctions against the lawyer and the.
And it was against the lawyer because the lawyer advised the client to do
Correct.
that. Yeah.
So, my advice would be do not remove anything from your Facebook page, but there's nothing wrong with limiting the people who can view your Facebook page.
Or even better, just deactivate. I would tell people just deactivate your page until this is over with, because if you deactivate, then you're not destroying evidence. You're just not letting anybody see it, and you don't have to worry about anything then.
Right.
But yeah,
and that certainly is an alternative, but with the caveat that don't remove anything from the page.
Right.
Don't destroy anything that was on the page, because you don't want to give the defense lawyer any ammunition that, well, you took something down that would have been beneficial to us.
Yeah, just like we don't like it when trucking companies suddenly lose a blowout tire or lose some defective part, or the logbook, the driver's logbook or something like that.
Right.
Something like that gets lost. We go after them for.
Or the dash cam video.
The dash cam video, yeah. And it's called spoliation of evidence, and it could result in huge sanctions against the defendant. Well, the same thing applies to plaintiff.
Correct.
Plaintiff can't go around destroying evidence either.
Correct.
So, I think everybody should know this, but once you put something on the internet, it's pretty much out there forever. I mean, it's you can't really delete it from the internet. People think they can, and they may delete it from their account, but it doesn't mean it's gone. It's in a server somewhere. It's in the cloud somewhere. It's on Facebook servers or Google servers or somewhere, and it just doesn't go away.
No, it doesn't. And defense lawyers have gotten very good about crafting subpoenas to companies like Facebook and Twitter and Instagram and YouTube to gain access to information from a individual's account. And so even though you may deactivate your account, it certainly is not going to prevent the defense lawyer from sending a subpoena to Facebook for the contents of your account.
Now, another way, it's even easier than that. All you got to do is create a fake profile. And what we generally do, if it's a male, we just get a really attractive female and send a friend request, and they accept us right away. Same thing with the females. We send a really good-looking guy, create a profile. Women send friend requests. Women go, yeah, I'll take you out. I know I get them all the time. I get these like really good-looking girls, sending me, friend requests, and I start looking at their profile, and I go, this is not a real profile. This is somebody that just wants me to accept their friend request so they can see what I'm, what's on my profile. So, I don't accept it. But it's not just that, but, your friends may share something. Let's say you got a photo with a bunch of your friends and they go share it. Well, guess what? Sure, it was on your account, but now it's out in the world. And so.
Right. I was, someone was telling me a story just the other day about the fact that, an individual had basically set all of their Facebook settings to private, but they knew a friend of the individual and were able to friend the friend. And then, of course, all the photos that you tag back and forth were now available so that they could go through the friend to see all the photos of this individual who had set all their settings to privacy. So
Yeah.
one of the things that you can always do also is to anytime you've tagged somebody, untag that photo so that it's not shareable again beyond just your page.
Yeah.
It's still there, but it's not, your friends they're not gonna be able to access it through your friend's account.
Anyway, I always tell clients, look, just deactivate your account till your litigation's over, but a lot of them don't want to listen, and they can do it anyway. So,
and it's hard to do. So the next best thing is to change the privacy settings on it, and then just if you ever have any question about, do I really want someone else to see this besides my very close family and friends? It's probably not something you want to put on Facebook.
Yeah.
And when I say most trusted friends.
Once again, we've written a book on how not to screw your case up. It's called The 7 Fatal Mistakes That Will Ruin Your Personal Injury Case in Texas. You can order it by calling us, by emailing us, by showing up here, or you can download an ebook from our website. So order the book. It's free, and it tells you all this and more. In addition, I just wrote a new chapter for a book that I'm authoring with I think 13 other lawyers on personal injury cases, and that was my topic too that I wrote about. So that'll be coming out here probably in the next 90 days or so. So we'll make copies of those available also. But anyway, I think our time is up. Let me just mention real quick about our scholarship. I know a lot of people were interested in that. We picked all our winners. We're going to be putting them up on Facebook on Monday. The winners were Alec Mertens. Yes, okay. He came in 3rd place from Rivera, Texas. Elisa Pena from Corpus Christi, Texas. She went to Veterans Memorial. She came in 2nd place, and the 1st place winner was from Plano, and that was Aki Kasai was 1st place. So great. We had 3 winners from Texas this year. I hope that continues. I'd like more winners from South Texas and the Corpus Christi area, the Rio Grande Valley area, McAllen and Brownsville. So we're getting ready to launch a new, probably by the end of this month, we'll have our new scholarship up for 2019. So we're going to be giving away the same scholarship money in December of this year. So stay tuned for that. We'll put all those up before the end of the month. Also, we're going to get our voter register to vote initiative started. And don't forget, we got Fiesta de la Flor coming up in March.
Is it March or April? I believe it's April.
Okay. It's either March or April. We'll as soon as we know more about it, for sure, we'll put it up on our social media. And also Valentine's Day is coming up here, February 14th. Is that right, girls? Right.
Yeah.
February 14th. So we will be having some Valentine's Day gifts that we're giving away in some contests. So stay tuned for those. So Scott, thanks for coming in again. Appreciate it.
Anytime.
And I will not be here next week. So we will see you guys the following Friday. So until then, be careful with your social.
Be careful with your social media.
And remember, if you put it up and then you get in a accident or something and you have to bring a claim, if you get rid of it, that's destruction of evidence. So just don't put it up in a place if it's questionable. So, okay, same channel in 2 weeks. See you guys then.